Good morning, Your Honors. The matter before the court this morning is the case entitled Santina Stone versus Dale Henneke, case number 23 AP 254. Representing the appellant, the Office of Child Support, is attorney Kyle Hatt. Appellee Dale Henneke is self-represented and is appearing by WebEx.
All right, thank you very much. Good morning, counsel. Good morning, Mr. Henneke. Sorry for the delay. Mr. Hatt, please introduce yourself, identify your client, and then proceed.
Good morning, Your Honor. I'm attorney Kyle Hatt, represent the Office of Child Support. And thank you, and may it please the court. At the crux of this case are the questions of statutory interpretation listed at the outset of our brief and answered in turn in parts 1A and 1B. OCS is the only party to ask the right questions and the only party to answer them. The first question is whether 15B VSA section 1307D required OCS to perform multiple currency conversions. The answer, no, requires judicial restraint. It beckons judicial restraint. It requires this court, unlike the magistrate, unlike the judge, to hew closely to what section 1307D says, to standard principles of statutory interpretation, to avoid abstraction and avoid policy questions. In particular,
Mr. Hatt, isn't there an economic reality to adjusting a currency to the U.S. dollars?
there is, Your Honor, if I understand the court's question correctly, yes, to the extent that exchange rates change.
Right, it fluctuates. And so isn't there an economic reality that a person is obligated to pay X? And that could be in euros, that could be Canadian dollars, it could be in any currency, or it could be in US dollars, but there has to be some conversion.
There has to be some conversion, and that's the conversion required in this case, in the first instance, by the Office of Child Support pursuant to section 1307D. So the question the court asks is a policy question. It's a policy question that the law already answers. And so the kind of question that Your Honor just asked, which implicitly is, how should the law deal with currency conversion in child support cases? What's a fair way to do that? What's better? What's best? Those are all policy questions the court must avoid, because that question has already been answered by the law. It was answered in section 1307D, and the answer is that
1307, if I could just interrupt you there, 1307D is a statement that's in fairly general terms, isn't it?
That's correct, Your Honor. It's fairly general. The requirements are limited. OCS was required as the responding support enforcement agency to perform a currency conversion. That was a practical necessity, as Justice Cohen referenced. It was a practical necessity because the support was ordered in Canadian dollars. And the requirement was to use publicly available information about an exchange rate to perform a currency conversion. And that's what OCS did. The fact that the statute's requirements are general, the fact that they're limited, doesn't mean they're ambiguous. And it doesn't give the court license to add additional requirements to the law that are not within the terms of the statute itself.
Right. And counsel, if we follow the trial court here and affirm what was done, doesn't that essentially lead to a standardless type of approach? I mean, it's done here under the banner of fairness, but one person's fairness is not necessarily the other person's fairness.
Absolutely correct, Justice Eaton. As we call it in our brief, the judge's affirmation of the magistrate was the apotheosis of abstraction. And what it really would lead to is one court deciding what was fair, another court deciding something different. There really would be no way for a support enforcement agency to understand what was required. And in fact, if we take this case as the example, the Office of Child Support could have proceeded to do the currency conversion in the exact way that the magistrate later invented, only to find a different court that had a different way of seeing things fairly and require OCS to retroactively revise its currency conversion if, as the judge saw it, Section 1305F allows a court, or requires a court to review and potentially revise retroactively a currency conversion lawfully done under Section 1307D. The fatal flaw of the judge's analysis in this case was a failure to ask how it is that Section 1305F relates and applies harmoniously with Section 1307D. It's a failure to read the statutes in pari materia. In addition, the judge failed to recognize that a support amount converted pursuant to Section 1307D was in fact converted, wasn't something that remained unconverted for purposes of its applying Section 1305F. So the judge seemed to think that in applying Section 1305F, what it was doing was taking the original amounts in the Canadian order and converting them because that was required. But as we point out in our brief, the way UIFSA is structured, as explained in certain commentary, is that Section 1305F in this case would only have required a currency conversion if that conversion had not already been done. And in this case, of course, it had already been done. And
Mr. Pat, so I just want to make sure I understand your argument here. So you're referencing the original Canadian order, and under the order, OCS was entitled to collect 1,003 Canadian dollars and 2,250 Canadian dollars monthly under the order. Is that right? Am I correct in that?
As stated in the original support amounts were what was stated in the Canadian order.
Okay. And so, and your argument then was that that was the end of it. There's no reason the court abused its discretion or committed error by making another conversion. Did I misunderstand you?
No, the court did not. So
Okay.
to state it snout to tail, our argument would be is that in this case, OCS was required as a support enforcement agency in the position of a responding enforcement agency to convert the amount stated in the Canadian dollars into US dollars. That was required by the law. It was also, again, a practical necessity because both parties resided in the United States. We collected support pursuant to that lawful conversion, pursuant to the rather limited requirements of Section 1307D for years. In connection with a determination of arrears made as part of a modification proceeding, the magistrate and the judge were not authorized to apply Section 1305F to revise that lawful currency conversion. So in this case, because the support amounts had already been converted, and because the court was zeroing the current support obligation, there was no question of a prospective non-zero support amount. There was no need and no authorization in the statutes for the court to revise retroactively the support amounts that OCS had lawfully converted. The court's discretion in reviewing OCS's currency conversion in connection with determining arrears would have been limited to questions like, did we actually charge the right amount of support according to our conversion? Did we calculate interest properly if that was an issue? Things of that nature.
But isn't it reasonable? I mean, the rule that you're sort of suggesting that we adopt here is that there's one conversion and one conversion only, and that continues on through the length of the child support till the child graduates from high school or is 18?
No, Your Honor, it's not a correct understanding of our position. Our full synthesis of the law is stated in in footnote 18 of our brief. And so what we're not saying is that there's one conversion only in all cases. What we're saying is in this case, a single conversion was required by the Office of Child Support. Because of the way the case unfolded, with our collecting support administratively for years, and because when we went to court, finally, the court was zeroing the current obligation, In this case, there was no need practically or judicially for a subsequent conversion. In another case, a court could properly apply Section 1305F prospectively to adjust a currency conversion. Thereafter, if, say, provided for in an order of the court, a support enforcement agency could apply an administrative conversion. So there could be plenty of other cases in which subsequent conversions are done, but the narrow question for this court of two is, did Section 1307D require OCS to perform multiple currency conversions? Require it? The answer is no. And again, to reiterate a point I made previously, Your Honor, but questions about reasonableness, questions about fairness, those are abstract questions to which the magistrate and the judge fell prey. They're policy questions. It's possible that this court might say to itself, are there different solutions to this question other than that which UIFSA provides? I'll leave that to the legislature, and this court should as well. And the problem with the magistrates and the judge's decision is that they became unmoored from the statutory requirements. And they became that kind of standardless thing that Justice Eaton referred to. I'll reserve the rest of my time. Thank you.
Okay, Mr. Henneke, you still there, sir?
Yes, I am.
All right, then we can hear you. So you understand you have 15 minutes. Please go ahead.
Sure. There was a point in time where I was mad at OCS for what they had done. At this point, I think I'm more disappointed than anything else. So let's see. Facts are, it's a Canadian order. The support amounts, both spousal and child support, are in Canadian dollars. OCS took over enforcement of the order in 2013. And they said that they were going to do it a certain way. They said that they were going to apply the exchange rate as the payment was processed, which honestly makes sense to me. Later, 2015, they changed their mind. So I noticed Mr. Hatt was talking about the court retroactively changing things. Well, OCS itself did. In 2015, they changed their mind. They went back to a retroactive in two ways. They retroactively changed their mind about how they were going to interpret it. And then they retroactively chose an exchange rate that actually predated, if I remember correctly, before me even moving back to the United States. So
Mr. Henneke,
Yeah.
I don't mean to interrupt you, sir. I apologize, but
Sure.
when it was converted on a monthly basis, that's initially what happened. So
No. Oh, sorry.
I
My
thought that's what you had said. I'm sorry.
It was per payment. So
Per payment.
I do believe that the judge was a little bit confused there. She said on a monthly basis, but actually what I'm proposing is per payment. I was actually paid twice per month.
Okay.
So the exchange rate. Yeah.
So every payment was, so was there a credit and a debit
Well,
that was
no.
associated?
My apologies for interrupting.
No, don't apologize to me. I'm just trying to figure out that.
Yeah. So
transacted.
This is what they told me they were going to do. They said they were going to do it on a per payment basis. In 2015, they changed their mind. The reason, okay, I asked I believe it was 2014, I contacted them. I asked, how much have I paid in child and spousal support? I need to know in order to properly file my taxes because they're taxed differently. When I asked that question, I believe it took on the order of more than 16 months for them to get back with me. It was in the summer of 2015. And that's when they came back and said, we've changed our mind about how we're interpreting this, and we're going to use this exchange rate going way back when. So they artificially created arrears. I had been following the exchange rate for a year and a half, and then all of a sudden they create arrears for me. After that, they started to use their enforcement prowess against me, including withholding my passport, which I'm a professor, or was a professor. I had equipment in Canada. I had equipment in Germany. I was unable to access any of that stuff during a tenure track position as a professor at Tech. God, I don't even know what to say here. Other
Which
than
is-
at this point, I'm just disappointed. I mean, we're talking about Mr. Hatt's talking about the legality of this. My question is, how can they go for so many years without registering the order? I specifically asked them repeatedly to do that. I wanted them to register it here in New Mexico, which is probably what they should have done from the very beginning. None of this would have been in question if they had done that. So anyway, does anybody have any questions for me? Because that's really all I have to say on the matter. I mean, I can, as far as I'm concerned, I can give the rest of my time to Mr. Hatt for the rest of his rebuttal.
So I just have a question, sir.
Sure.
Regarding the way that the magistrate and then the was appealed to the Superior Court, that it was a rule that said it's the first day of the year is the number that's used for
Yes.
conversion. Do you have any thoughts about that or any?
I do actually. First of all, I would like to say Magistrate Hoyt, I thought was a wonderful person. Okay. So I want to give her credit for that. And I think she tried to come up with something that she felt was reasonable and fair. And I actually, under UFISA 1996, I do believe that that would have been reasonable and fair. If you go back to 1996, people would look for exchange rates in their Sunday paper. Computers weren't omnipresent. UFISA 2008, I feel like there's a push to try to get things to go on a per payment basis because computers are omnipresent. You should be able to, if you have a question about how much support you owe, you should be able to go online and look these things up. So with the current precedent that Magistrate Hoyt set, I do believe it was fair under 1996, UFISA 1996. Moving forward, I do think that that's a terrible precedent for the state of Vermont going forward. On an annual basis, that's going to be a hard thing. Especially if we're talking about exchange rates here. Well, what about digital currency? What if somebody comes into the Office of Child Support and makes a payment with Bitcoin, for example? Okay, so there's an exchange rate involved. Are they using the exchange rate? So fine, they make a payment on, I don't know, it doesn't matter, March 15th, they make a payment. Let's say they come back in July and make another payment using Bitcoin. Are you using the exchange rate in this case, the currency conversion rate, back to March, or are you going to use the one the day that they make the payment as the payment's processed? That to me is logical, especially where we are with technology now. In the past, it did make sense to do it, on an annual basis or something like that when the communication wasn't so easy, I guess, is what I'm trying to say. I don't know. Are there any other questions? That's just my
Henneke,
perspective. Sure.
I
Yes.
have a question. Thank you so much for your comments. They've been very helpful. I'm just a little, I'm curious. Are you saying that you agree with OCS at this point that it should have remained as the one-time conversion?
No,
or
not at all.
Oh,
No,
okay.
no. I
Can
was
you-
completely misled by OCS. They told
Okay.
me they're going to apply it as they process the payment. Year and a half later, more, I'm not sure exactly, but over a year later, they changed their mind. And they said, we're going to apply it a different way. I'd been watching the exchange rate the entire time. And then,
But it went, can you just help me a little bit?
sure.
It went from what to what that you didn't
It went from,
approve of?
okay, so it went from they explained that they were going to apply the exchange rate as the payment was processed. Sounds fine to me. Makes sense. I was upset that they had taken over the order. If we're talking about following the court order, it actually says payments are to be made to Fro. And that's what I was doing before OCS took it over, by the way, they didn't inform me of that, by the way. The way I found out about OCS taking over enforcement of this was through my employer when my paycheck was light. They contacted my they contacted my employer to do wage garnishment, but they didn't bother telling me that they were going to do that. So that also happened. I don't know. This entire thing was a mess from the very beginning, but here we are. So I don't know. If you're talking about wanting to have faith in a government agency, I don't think you should allow a government agency to retroactively change its mind with a serious financial consequence like that. It just should not be permitted. I mentioned Chevron deference in my brief and how it should not apply, because I do believe what they did was unlawful. That's really, again, all I have to say on this. I don't
So
know
you,
how much.
you agree that deference would only apply if they did their job correctly? Does that be the,
Oh,
that-
sorry.
no, deference would apply only if they do their job correctly, otherwise. there's
Yeah,
no-
exactly. You can't just arbitrarily change things from one extreme to the other. That's just, you can't have faith in a government that does that. So I mean, sure, I know that we're supposed to, defer to their decisions on these things, but not if they're totally arbitrary, I believe is the word that in the Vermont statutes. Arbitrary decisions. You can't do that. It's just not right. Sorry.
Okay. Anything else, Mr. Henneke?
No, but I do want to
All right.
thank everyone for their time.
Thank you.
Welcome, sir.
Thank you very much. How much time does the appellant have, please?
Appellant has 4 minutes and 11 seconds remaining.
Counsel?
Thank you, Your Honor. A few points. I'd refer the court to Appeal Volume 1, page 364, page 359. That addresses the question of whether the Office of Child Support reversed a prior decision to perform the currency conversion in the way that Dr. Henneke described. The magistrate made a finding about that contrary to Dr. Henneke's understanding about it. In addition, I refer the court to footnote 21 of our principal brief, page 7 of our principal brief. The record in this case establishes that although there was a period during which the Office of Child Support had not come to a final decision about the currency conversion, that thereafter, Dr. Henneke was aware of our decision that we made, the final decision. He was, at least at various points or a certain time, watchful of the fluctuation in the currency conversion and decided not to pursue a resolution of any objections or questions he had about that in court. And that's another reason why the judge's analysis applying Section 1305F can't be affirmed, because it would facilitate the kind of irrational result seen here, in which support is collected for years and only in a belated fashion as part of determining arrears in connection with the modification is the issue of currency conversion raised in the court's decision.
Mr. Hatt, can I ask you to clarify something for me? I'm sorry to interrupt, but I want to make sure I can ask this. It was my understanding that once OCS decided how to make the conversion, it was a one-time conversion. And it sounds like Mr. Henneke's suggesting that there were different methods of conversion by OCS itself. Which is accurate?
The former, Your Honor. In 2015, the Office of Child Support decided in a final way how it was going to address the currency conversion. Until that point, as described in the record in the magistrate proceedings, that question was unsettled. And it is the case that when we made the decision in 2015, the exchange rate the currency conversion approach that we decided on was applied retroactively, in the sense that it was applied from the start of when we were collecting support forward. But it isn't a retroactive revision in the same way that the judge did, because the judge was undoing the currency conversion that OCS had already done, whereas OCS was simply applying a currency conversion that had not been decided on a final basis till that point. And Dr. Henneke, and I think that, I'm not sure that Dr. Henneke refers to the Office of Child Support's decision as arbitrary, but it was the exact opposite, Your Honor. We were applying a standard. We were We applied a currency conversion that complied with the law. And to the extent that that approach mirrored Ontario law at the time, I would refer the court to our footnotes 3 and 20, I believe, on that issue. To the extent that our conversion at the time complied with or mirrored Ontario law, was the opposite of arbitrary.
And now Ontario law has now changed, correct?
Right, and exactly the similarity of our approach to Ontario law at the time and the contrasting Ontario law currently really elucidates what Section 1307D requires and what it doesn't. And the result that the judge produced, Your Honor, is like an awful sound that something makes when it's not working right or smoothly. The synthesis of the law that the Office of Child Support provides, it fits, it makes sense, and this court must put things back where they were and reverse the family division. Thank you.
Okay. Thank you.